So this is concerning the demonetization.
Yes, sir.
We are ready, my lord, any date subject to your lordship's convenience.
And all others. Does this survive this at this stage?
Milord, what has happened is, Milord, there is an order of your lordships framing several questions.
That's
Nine,
right. In those days, it was very relevant. Does this survive?
But there are two issues, one of which clearly survives. One was the issue regarding the validity. So there were petitions regarding validity. They've brought in an ordinance on 30th of December 2016, trying to give legal validity retrospectively. That was the first issues which were framed by that order of 16 December. But the second was, in that order itself, the court said that no High Court will entertain any petition arising out of the government's decision to demonetize 500 and 1,000 rupees currency notes. So the petitions, there was no 226 remedy available. The Prime Minister, RBI, everybody promised that those who were unable to deposit their notes by 31st of December 2016, they would be given an opportunity till 31st of March 2017 for good reasons. If somebody died, somebody's money was deposited, somebody was abroad throughout the entire period and the money was lying in the house. So therefore the 226 remedy was, and then on the last minute of 30th of December, they brought in an ordinance that we will not take the money. And now no further. And they brought only two categories in that.
Sir, you are arguing. What is
One
the?
second, I'm telling
what
the
is-
live issue. So,
No, the question was only whether anything survives.
yes.
That's.
If anything survives,
So,
then
if your lordship allow me to say something here.
we are only of the view, nothing survives, then there is no point.
Because there are individual claims apart from
All
the
of you are
constitutional
all of you
validity.
are adamant that something survives.
There are individual claims apart from the validity. Because there are applications
There are
filed.
two aspects.
Your
One
lordship
is,
just see the order dated
Let's be
3rd
on the
November 2017.
Mr. Sharma.
there are two aspects of the matter. One is questioning the validity of the action. The second is with regard to the implementation of the same and the problem arising. Now, what has been put is with regard to the survival of the validity as such. The second is if there are problems in the implementations where you have expressed that there were problems who could not exchange the amounts, etc. That is a different aspect. So you'll have to keep.
If your lordship allow me to say something, my lords, there was an order
Yeah.
3rd of 11
I would earnestly
2017.
request Mr. Sharma's matter be detailed. So this is the problem on his side and on our side. Both sides are facing. So the answer to your lordship's question is, for all practical purposes, it may not survive. If as academic issues, the honorable bench would like to examine that, we are prepared. Otherwise, my lord, it will not survive. That's the answer.
There are individual applications, your
Five
lordship.
judges spend their time for deciding academic issues.
That's all, my lord, I am submitting, my lord. It need not be.
We are already burdened with so much pending.
So much live matters where rights are involved, my lord.
So, my lord, there were two categories.
May I request your lordship, if your lordship allow me to say something?
Where validity is not questioned.
No.
They were separate initially. The matters in which validity is not questioned, those writ petitions, several orders were passed, and ultimately those writ petitions were said that they will become interveners in this, and their individual grievances will be dealt by the Constitution bench. If that order I have annexed in my IA.
How would the constitutional bench deal with the individual grievances? If there is any reference to that will be answered.
Let me submit. Let me submit.
The purpose of filing was so that the question because of the mass level exercise which had undertaken at that point in time. So certain important orders were issued by the Honorable Court. And therefore the central government has also implemented, therefore they had allowed the circulation of 500,000 rupees, the denominatized currency for certain reasons. And thereafter with regard to the withdrawal also certain enhancement of limits were also
Please listen to us, please listen to us. We will fix it on 12th. Please come on that day. But we are going to examine whether it has become academic in nature, whether it requires consideration at all. This will be the first question,
Yes.
right? Please listen to us. See, we will hear you on that day. 12th, we will fix it. And please come on that day. Let us see how.
Please.
I want to submit one point. Please, Your Lordship, give me a time, give me a chance.
Come and say on that 12th.
Today itself, Your Lordship, then you can examine all that on 12. That's why I just want to say something. I'm not going to argument anything. Your Lordship, there is 58 petition.
Mr. Sharma, are you appearing as in person?
Yes, Your Lordship.
Look at your
I'm not wearing the gown.
wearing the band.
Oh, you are saying hurriness before the court. You know the advocate always.
What do you mean by hurriness?
No, Your Lordship.
Some decorum has to be maintained.
Just only mistaken. I am removing it. Your Lordship, now permit me. You say there are 58 petitions. Out of them, 57 petitions are civil nature, one petition in criminal nature. Now, Your Lordship, Constitution bench is to resolve the constitutional issue only. They are not sitting for issuing the procedure, policy, all that part. You say, please put this point. If any petition is having challenge to constitutionality of the ordinance, it should be taken up. If some petition are there for the procedure,
List on 12th.
oblige you.
Grateful.
You come on 12th, you know. We have not disposed of. Come on 12th.
Interveners also very hurt.
Have you dismissed your application now?
No.
Please come on 12th, let us see on that day.
Very deep of that.
Because interview.
So far as item 502 is concerned,
Yes.
my lord, the contours is the freedom of speech. And what are the limitations? Lord, your lordships would recall, I will not take names, but one former Honorable Chief Minister made certain remarks with regard to some, my lord, unfortunate incident of rape having been committed. My lord, according to me, by subsequent judgments, my lord, this law is fairly well settled. But, my lord, we are prepared fully. If your lordships would like to be assisted, what are the contours of freedom of speech?
No, but I saw from the records, the concerned person has apologized and his apologies already accepted. So whether this has also become academic,
Lord,
because he has apologized and apologies accepted here.
Shall I make a very short response to your lordship's query, my lord? I am in I am the next item tagged along with this. My respectful submission to your lordship's query would be this. So this particular case arose from certain statements made by the then minister in Kerala, which were containing disparaging remarks against women, certain employees, laborers, etc., etc. Then the question arose, what is the limit of freedom for the public functionaries? Well, this is an issue which is being repeated again and again. And in fact, in this matter, another bench heard it to some extent, and we even submitted written submissions. That bench cannot be reconstituted because their lordships, respected lordships, got retired. Now, your lordship may have to address certain fundamental issues like limit of freedom to the constitutional functionaries, including the ministers, the MPs, the MLAs, etc., etc. This is a recurring issue happening here or there, very frequently being repeated. Therefore, I would say, it may not be an academic issue. Your lordship may fix a date. We have, in fact, not made a thorough research on this as to whether the freedom of a minister is akin to a freedom of an ordinary citizen, and how that will affect the constitutional values, if not constitutional rights. So these are the matters which will have to be deliberated. We conducted an extensive research on this. It may not be limited to that UP chief minister's issue alone. Even thereafter, even the central ministers or state government ministers will often repeat this. Therefore, this is an issue of vital importance. And that is the reason for referring this. And the reason for reference still remains relevant.
Lordships, I appear as an amicus in the matter, and I agree with the learned SG that these are the matters which have always developed case by case, Your Lordships. So in this particular case, the issue was fair investigation, and the person has already apologized. And we filed our written submissions, and this is our submission that these issues have already been decided by Your Lordships in various judgments. The various rights, fundamental rights, they have been balanced inter se. So Your Lordships may take it up, and I think we can should.
So is it the right of only ministers or all other lawmakers? Because whatever statements they make in public, that may have a bearing because ultimately they are the lawmakers.
Correct.
Yes.
Public functionaries, let us
That
not
is
be.
public functionaries, a very broad category, very
Yes.
general category.
No,
Not
even
just ministers.
MLAs and MPs are also public functionaries.
Yes.
So Lordships, this particular aspect is fair
Here
investigation.
incidentally, one of the chief ministers.
Lord, some of the persons, my lord, may or may not be MLA or MP, but still as a leader, he may be in the capacity of a public figure,
There we may not be.
a party president or something. But the
is-
point is this, my lord, whether Article 19(1)(a) and the exception thereto would be differently applied to public functionaries while they are speaking to a larger audience or not. That is the question, which is a live question. Thereafter, my lord, after framing of this question, this is a matter of 2016. The contours are, my lord, defined, as the learned amicus rightly says, on case-to-case basis. And it would essentially be, my lord, it would not be possible for your lordships to lay down straitjacket line of distinction that you can cross this line and not this line. It would be an individual case where law will have to be invoked. Somebody makes a statement which is not strictly in accordance with 19(1)(a), but transgressing his right, freedom of speech. But the question is important, my lord. My learned friend, my lord, has.
Your colleague has done an exhaustive research.
Yes, my lord, we have done the research.
So far as
See,
Available in public domain.
see, right to freedom of speech and expression is essentially against the state. And 19(2) are the reasonable restrictions. Now, if a particular person has made a speech which is not liked by somebody else, then that somebody else can always take action. Now, when 19(2) is already there and 19(1)(a) is there, there can't be some other restrictions over and above 19(2) which can be imposed because the Constitution doesn't recognize that. Therefore, the question is, if anybody is aggrieved by somebody's speech, what action can be taken?
Your ladyship, my lord, your ladyship is absolutely right. My lord, in fact, our written submission is in this line. Or may not be in, because of 19(2), a further restriction, that to a judicial restriction, may be apparently impermissible. But at the same time, when there are horizontal right violation, what else could be done? In fact, my lord, in our written submissions, we have made a suggestion how a constitutional restriction can be made without hampering the constitutional values. This is the purpose. We have suggested a kind of promulgation of self-regulation for public functionaries, borrowing, my lord, certain models from other jurisdictions. We have placed it right from England and from Australia, how the public functionary should behave publicly. That is very important. For example, but in the Kerala minister's case.
This is one aspect, please listen to us, but it requires a factual background, right?
That's right.
You can't decide a question in thin air. You need certain facts. On the basis of the facts only you have to decide.
Each one.
Now, we don't know what the facts are here. Can you lay some general guidelines, without factual background?
so far as Kerala case is
I may answer that. In fact, as far as Kerala case is concerned,
Okay.
this arises
So
from a
far as
matter
UP case is
from Kerala
concerned,
High Court.
Just 1 second. What is that?
so far as UP case is concerned, my lord, there has been an investigation. Subsequently, the chief minister opposed. So far as Kerala case is concerned, once when he was the minister, he made a remarks like this. Then we moved the High Court. High Court said nothing doing. Thereafter, we were granted liberty to come here.
and we were granted liberty to get impleaded here.
Who are you? Who are you?
I am for an intervener in Kaushal Kishore's matter. Therefore, that fact remains. Thereafter, what happened is he still goes on making such kind of remarks. Therefore, my lord, this has to happen. So, at least so far as Kerala case is concerned, there has not been an investigation. No investigation happened. No report came.
Does he?
No apologies.
Please listen.
Yes.
Does he deny that allegations made, or does he admit and he said
He admitted, and thereafter
he asserts it?
yes,
He has
he
a right.
asserts it.
He
And
admitted that
one
he
such
still
one of his remarks ultimately resulted in some other case being reinvestigated, further investigated, and a final report being preferred. He made a submission.
the facts
This case on 12th November.
12th. Yes,
We have hardly 2 weeks.
Yes, yes, yes.
we have placed
I must say, my lord, as an officer of the court,
facts
that
will be
threshold,
discernible.
only a minute.
1 second. Facts will be discernible from the memorandum itself. Lord, it is stated from
Yes,
page
sir.
F to K.
1 minute,
Facts
Mr.
are-
Consul, please,
We
1
will have
minute.
it. Oh, no, we can have it only.
Saturday.
No, 15 November.
I'm sorry.
November.
Grateful.
List it on 15th, right?
Yes, my lord, I must say, my lord, the threshold of my right as a freedom of expression, speech and expression, if I am in a public leader capacity, would be much higher. There is no doubt about it. A layman can say whatever he wants, and a leader may still not be able to say whatever he wants. But to judicially define that demarcating line would not be, my lord, a
It will be
easy
difficult.
exercise.
And it has always to be related to the factual situation.
Factual situation. It will have to be subject to.
Actual situation, my lord, in Kerala case, my lord, has been indicated right in the judgment and even in the SLP, my lord, 3 instances. And after the instances, not only that he didn't deny it, he even reiterated it. He even justified it. My lord, that is a big problem. And similar situations occur elsewhere also. Therefore, this requires a deliberation.
Lordships, in this particular case, the issue is fair investigation and balancing the right under Article 21, which is a fair investigation, and right to speech. So, Your Lordships, this issue has already been decided. We'll show it to Your Lordships, and Your Lordships will then examine it and lay the guide.
We will have it on 15th,
Yes.
right?
Yes.
List on 15th.
Yes. My lord, may I make one submission? 107414. I am the intervener. My lord, may ask. My name is not being shown. Therefore, I will have.
Show his name also.
Yes.
Bribe to vote in a particular manner in Rajya Sabha election. Earlier, there is